Hello, it's Carl Merkle here. It is December 4th, a Friday. I'm coming to you from my backyard. We have a little bit of dog noise, but I want to show you three documents that I'm going to be talking about right now. This first one is a brief for appellant filed in case number 20813 yesterday, Carl Merkle versus David Gragg, Natalie Fern Wilson, Patrick Autry, and Johnny Thomas. This is basically a criminal indictment against those that's in the Fifth Circuit, and I have a matter currently before the bankruptcy court. The second document is a document that's labeled as official business. I received that in connection with a mailing that the court system sent out, and so the court system sent this letter. And the letter basically says, from United States Bankruptcy Court, Western District, and it says to the, in RE Carl Merkle, case number 1650026 CAG, to the debtor/debtor's attorney, the bankruptcy court through its bankruptcy noticing system sent this, and it got returned back. And this document is fairly extensive. I'll just show you the front of it. It's a notice that really got sent to everybody, and it says it was a notice of appeal in demand for jury trial from an inferior administrative court of equity to an inferior court of law in the statement of election. A slew of individuals and companies and the USA stole Merkle's hazard insurance money, and through criminal conspiracy in 18 U.S.C. Chapter 19 conspiracy, Section 371 violation, among a slew of other criminal law violations, have known about alleged Section 373 violation, have now, as of August 24, 2020, embezzled and extorted a total of $1.3 million from Merkle's bankruptcy estate through false claims, a sham judicial record that has concealed such alleged crime through fraudulent presentation of facts using embezzler's facts, and the most recent theft and embezzlements. I'm not reading it real well. Embezzlements by Craig A. Gargata and the Chapter 7 trustee Johnny W. Thomas are $161,000 stolen on April 13, 2020, and $175,000 stolen on August 24, 2020, respectively. God Almighty is angry about the inequity and injustice and is displaying His glory through current headline events. So that's it, and this document goes on for about 50 pages and basically discusses what occurred. This is a escrow statement showing money that was essentially stolen from me. I paid off a disputed lien. It shows that it was signed by the escrow officer and myself, and then shows the specifics of what the dispute is. And then this is the bankruptcy judge compared to who's an enforcer for organized crime, compared to a enforcer for the Kansas City crime family. Both have the same last name, first initial of the first name. So Craig Gargata, Judge C. Gargata, compared to C. Mad Dog Gargata. This basically tells what the crime the bankruptcy judge did. This shows the stolen hazard insurance check. This shows the accounting fraud. Basically the scribbles on this thing are scribbles that I've made. This compares the first proof of claim against the correct numbers. And then this gives some introduction to what some of the papers where they don't have a note. A little bit more discussion on that. Then it goes into the fact that the company that they're claiming is a note holder, but it's just really a note. They're claiming it's a note holder, but it's really just a note owner. It shows it's not in business anymore. This shows part of the criminal conspiracy with this Johnny Thomas and these other people. Again, talks about the components of the the embezzlement, then how I accounted for the note, gives some lengthy description of it through the briefings in the bankruptcy court, gives a little table summary of it, and then lists some of the embezzlers. Before it gets into the embezzlers, it talks about some of the current events that have gone on during the year. It's in black and white, so it doesn't give you the full effect of the Second Chronicles 7:13 and Ezekiel 14 plagues. But then it talks about the statutory embezzlement of fiduciary property and who those individuals are. There's quite an extensive list. Statutory theft was committed by a number of people. Lists that. Talks about reasons why retrial is necessary. And then it gets into some schedules of revision of what my numbers were when I filed for bankruptcy versus not. And then basically talks about the attorneys being wolves in sheep's clothing. And then part of the reason for coronavirus, which I'm saying is connected with this case, is to cover their faces in shame so that they'll seek God's face. And then it gives a little bit of background on some of the Constitution. My case is a constitutional violation. And then they ended at the 50th page, in which I basically gave a summary of how you select wise people. So the judge is not a wise person. He's acted like what the Bible calls a foolish person. And then I got this last week, and this is basically a notice. So it's dated, so it shows here November 25, 2020. Sent by their system. These are the attorneys at Langley and Benak that sent this to me. So let's go through this document real quickly. This is a notice of expedited telephonic hearing, and it has a phone number, tells you when to call. Call's going to be on December the 10th at 9:30 a.m. via this phone number. Anybody can attend it, so I'm going to highly recommend that all of my friends attend this telephonic hearing. This thing is signed by David Gragg and Natalie Wilson, who are the two individuals who've now embezzled $1.3 million from me. And then it's emailed, or basically included as a list of service. Myself, the Chapter 7 trustee, who's a criminal behaving Chapter 7 trustee, the attorney for Janie Merkle, who's also criminally behaving, and then apparently the U.S. trustee, who's also been behaving inappropriately. Shows who the list of service are, which were the identified creditors of my bankruptcy estate originally. I would have never filed bankruptcy. This then shows a emergency hearing approval by the judge dated November 24th that got filed on the 25th. So it's a rush to get this thing done. It's prepared by Wilson. We got Johnny Thomas, Gragg, Wilson on here. And then this is a joint motion. So this says that comes now Pilgrim. Pilgrim is not one of their clients. They've never had a contract with Pilgrim. It says comes now Pilgrim and Capital Crossing Servicing Company. So together with Pilgrim, it's saying the secured creditor. Well, Capital Crossing is a loan servicer, and Capital Crossing and Pilgrim cannot be together. Neither of them had were able to provide a proof, a document that showed that they had the note originally, and I can go back through these papers, but I won't. There's testimony within these papers that show. Maybe we'll go to it, because there's testimony in these papers that got sent out to everybody that show that Pilgrim is not a note holder, because Pilgrim had to, by May 7th by May 4th, 2017, had to present a proof of claim in writing supported by a preponderance of the evidence that that showed, oops, I'm going the wrong way. That they were a note holder in writing by May 4, 2017. They did not do that. I found out through this hearing. The hearing was completely unnecessary. So here we go. This is a testimony given on June 21st by Kevin Shea. The question he was asked by his attorney is Pilgrim or Capital Crossing currently in physical possession of the original note? His answer was, no, it is not. Question was, do you know if Pilgrim or Capital Crossing ever was in physical possession of the original note? The answer, he said, was, it's my belief that we were. And then the question was, what is that belief based on? The answer is, it's based on, we have like a original note file, and there's a little sticky, essentially, for lack of better word, that indicated in April of 2014 it was provided to Mr. Goddington to send to counsel. So they didn't have a note, and therefore they cannot call Pilgrim a secured creditor. Secondly, Pilgrim was not named on that hazard insurance check. Here's the hazard insurance check. The check was made out to Carl Merkle, doing business as Northeast Village Apartments and Pilgrim Grantor Trust. So Pilgrim REO LLC is not Pilgrim Grantor Trust. And the apartments, when I was doing business as Northeast Village Apartments, these are the apartments here. That was me. That was my personal residence. And then the top unit of this property right here is the unit I lived on. That was my sole and primary personal residence. And we were planning, when we bought this particular property, to convert this into a manager unit. We managed the property from that unit. We would have just moved over and moved into this, and then this would have become our primary residence. But at the time all this went down, that apartment complex was my sole primary personal residence. And so Carl Merkle, doing business as Northeast Village Apartments, is me. The 4535 Church Road, number 406, is where I used to live. Now I live right next door here. And so this piece of paper is an absolute lie at the very outset of it. According to Texas statutes, you have to be both a note owner and a note holder in order to foreclose. They attempted to foreclose on me using bad accounting. I was never delinquent on my loan at all, and we can see through the papers that I had drafted. If we get to there again, let's see if I can find it. How Merkle accounted for the Pilgrim note. So here, how Merkle accounted for the hazard insurance money, and we'll go through this. Okay, so here I start talking about it. In January 2015, Merkle paid $6,446.82 and applied $4,239.75 of hazard insurance to his loan, for a total revised monthly payment of $10,686.56, which included $508.87 in late charges. B, in February 2015, Merkle paid $6,446.82 and applied $4,239 $1,075 of hazard insurance to his loan for a total revised monthly payment made of $10,686.56, which included $508.88 in late charges. In March 2015, Merkle paid $6,446.82 and applied $4,239.70 of hazard insurance to his loan for a total revised monthly payment made of $10,686.52, which included $508.83 in late charges. In March 2015, Merkle made an additional $501.73 payment at the request of William Garlington. Merkle treated that as a monthly escrow account addition. In April 2015, Merkle paid $1,000 and applied $9,686.52 of hazard insurance to his loan for a total revised monthly payment made of $10,686.52, which included $508.83 in late charges. In May 2015, Merkle paid $1,000 and applied $9,686.52 of hazard insurance to his loan for a total revised monthly payment made of $10,686.52, which included $508.83 in late charges. In June 2015, Merkle paid $6,446.82 and applied $4,239.70 of hazard insurance to his loan for a total revised monthly payment made of $10,686.52. In June 2015, Merkle also applied $9,770.82 of hazard insurance to his loan to pay delinquent interest in full for January to June 2015. In July 2015, Merkle paid $6,446.82 and applied $4,239.70 of hazard insurance to his loan for a total revised payment made of $10,177.69. In August 2015, Merkle paid $10,603. In September 2015, Merkle paid $10,603, which included late charges. In November 2015, Merkle paid $10,603. In December 2015, Merkle paid $10,603. In total, Merkle's scheduled monthly payments in 2015 were $122,132.28, and Merkle paid using the application of $49,833.63 in insurance on a monthly basis as required by paragraph 5 of the deed of trust, a total of $137,159.15. And then I created a little chart, and nobody seems to understand charts. So the words basically say that I paid every single monthly payment during that year. So they get into this lie that says that Pilgrim was a note secured creditor, which is not true. Pilgrim, because it did not possess the note, which was testified to, was just an unsecured note holder. And then it goes into some background. These backgrounds are basically false in the sense that paragraph 6 says it says that paragraph 5, Pilgrim or its predecessors were the holder of the loan documents at all times, and that's just a lie. Then it says in paragraph 6, at various times prior to September 2015, Merkle was in default of the loan documents for failure to make monthly payments in full and on time, among other things, but we just read that that's not true. And then it gives an example of something that I never received notice on. And in fact, Janie does not have right now any form of second lien on the property because of the litigation that we've incurred. All she has right now is a 1/7 equity interest in the property. So paragraphs that are listed here are incorrect. And then it says in September 2015, Pilgrim initiated foreclosure proceedings pursuant to the terms of the loan documents, which is inaccurate because they didn't do those right. So then it does say that to avoid the scheduled foreclosure sale On January 4th, Merkle filed for bankruptcy protection, and I filed for bankruptcy protection because they had created a fraudulent accounting that said I was delinquent. Then it said Pilgrim filed a proof of claim as amended, and I objected to these claims. Their proof of claims were all false and fraudulent. And then it talks about, on or about March 28, 2017, the bankruptcy court confirmed the plan. And then actually they confirmed the plan for $940,000, and then they just stuck in this $964,000, which is fraudulent. And so this paragraph 10 is fraudulent. And then because it was supposed to be Pilgrim $940,000, and then on or about they paid this $967,000 from the sale. They hid that sale, so this paragraph is also misleading. And then they said they held a contested hearing to adjudicate the claims, and they didn't date these claims, but one of these claims came in too late to have been heard. And so this whole document that's here, it's already starting out. It's a fraudulent document as it's drafted. I don't think I'll go through the rest of it. I can talk the court through it at a later point. But the most significant aspects of it is that there was no note. The bankruptcy plan, when it was approved, was fraudulent, had a fraudulent amount, had a fraudulent statement of Pilgrim being a note holder. So I don't know if I can switch this this thing, but I'm going to basically conclude this by saying that I've got a hearing coming up next week. These documents are going to be on here. Gragg and Wilson, who wrote these documents, don't even have a contract with Pilgrim. Pilgrim had been to the Fifth Circuit in this case, case number 20-50014, had been in with just Gragg and Wilson as the attorneys and Pilgrim, but they don't even have a contract with Pilgrim, so they don't have any authority to collect for Pilgrim. And so what they're doing, what they're planning to do, is they've reached a settlement in this agreement with this Chapter 7 trustee, who is not acting in the best interest of the bankruptcy estate. He's only acting in the interest of Gragg and Wilson. Gragg and Wilson are criminally behaving attorneys, so they've got this Johnny Thomas, Gragg and Wilson, with Judge Gargata. Judge Gargata was named in the original lawsuit. That's now part of this paper that I filed yesterday. This says basically these guys have stolen the money. So this is a certificate of interest persons that says that that they were that they committed crime. Then I list the interested parties, but I basically talk about myself on this first page, and what my role is and how God hired me to be a Chapter 7 fraud auditor. Then at the end of the document, because this is just an excerpt of the document, I have a notary public affidavit speaking of the theft and embezzlement of my money, and I include some YouTube videos. Basically, anybody can go out to YouTube and look at those existing 5 videos, and then I'll post this 6th video before things are over, and then I close it with a signed notarized affidavit. So that's basically what I'm going to be presenting to the court of public opinion. These guys stole and embezzled $1.1 million, as shown on the escrow statement, which I'll post on the internet. My case actually tracks fairly closely. It's an accounting fraud case, and it's amazing how much the accounting fraud on my case and what's gone through tracks kind of what occurred in terms of the national election, which is also an accounting fraud. It's an accounting fraud concerning votes. So Capital Crossing, who's a loan servicer, a former Lehman Brothers subsidiary, lacked a sufficient system of internal accounting controls to make sure that it accounted for loans properly. And at the time that we've received this packet of documents from Langley and Banach, where they purport to represent Capital Crossing together with Pilgrim, it's basically a lie. They absolutely know that what they're doing is illegal. Thursday, we'll see what the judge does. But right now, the judge is part of a conspiracy with them because of screws that were placed in my tire. There is nobody who has any form of immunity, attorney or judicial or otherwise. Therefore, they can all go to jail. And that's where this thing is. A pretty serious matter. I'm done, but basically I swear that I've told this whole thing, the truth, the whole truth, and nothing but the truth, so help me God. But yesterday I sent off this document, and I sent off an indictment that ended up being like a 2,600 page indictment against Gragg and Wilson, consisting of all of the various the documents in front of Judge Gargata and from some of the appeals process that are basically fraudulent. I might have more, but my case is pretty simple to prove. I believe it'll be simple to prove to a jury what ultimately occurred, but it just shows that the judges are corrupt and lack integrity, and that the attorneys are corrupt and lack integrity. And that's what's happened. We've had a tremendous moral decline in this nation, and until this nation repents and turns to God and repents of its evil ways and turns from the evil ways, we're going to continue to see things like coronavirus and these other things affecting us. This Joe Biden being this named president-elect by the mainstream media and essentially big tech is just another Second Chronicles 7:13 and Ezekiel 14 plague. It's basically an oppressor who's being placed in front of us. Okay, folks, that's it. I loved you. Thank you for spending this nearly 30 minutes going through these papers with me at my home and at my former personal residence, which just happened to be a 28-unit apartment complex that the Lord has graciously granted me as of May 4, 2017, complete forgiveness on the loan, because these guys, these attorneys who I have sued, did not file a proof of claim in writing supported by a preponderance of the evidence on May 4, 2017. And so the Lord has taught me a whole lot about the legal process through this, but granted me basically relief of my debt as a result of the attorneys messing up, screwing up, and now they've committed serious crime and could spend some serious time in jail. It looks like they've won all the way, but they made a really stupid move for this hearing that's coming up on Tuesday of next week. So again, here's the phone number. Write that phone number down. Write down the access code. I'll give you the phone number, 650-479-3207. Access code 160-591-1937. Hearing is on December 10, 2020 at 9 a.m. via telephone only. That's Central Standard Time. So if you're at all interested, this very well does tie into the national matters, but it shows you how there's something that it would look from a judicial evidence standpoint like these guys have won, and we'll see what the judge does with this stuff. But I can tell you, God is the judge, and God has set things up for these guys to take a fall. Read Psalm 64. That's God's promise to me, That's what's going to happen to these guys. Okay, God bless you. Love you. Take care. Have a great day. That's 30 minutes exactly. Bye.